and thank you for joining us for the first session of our in-house Counsel CLE webinar series, Grow, Protect, Operate, and Finance. Before we get started, I have a few housekeeping notes. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the chat box at the bottom of your screen. If we cannot address your question during today's webinar, we will follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Please note, Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. The following is a very important message regarding CLE credit. The webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use the computer outside the webinar software, and this will prevent your earning CLE credit. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during each presentation of this program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard this. And now I will turn it over to our first presenters.
Thank you, Casey. Welcome, everyone. We're so glad you're here to join us. I'm Lori Chesser, and I'm the chair of the Immigration Department at Dentons Davis Brown.
Tim Wheelwright. I'm the chair of the immigration section in Dentons Durham Jones Pinniger, and I'm based in the Salt Lake City office.
Good afternoon. My name is Anna Maria Mielis. I am a shareholder in the immigration group of Dentons, Cohen and Grigsby. And today we are going to review with you the immigration considerations and best practices involved in attracting, integrating, and retaining foreign national talent. Next slide. So first, an introduction into some basics of immigration. Visa categories for immigration purposes are designated by purpose. So if you intend to visit the United States, you would need a visitor visa. If you intend to work, you would need an employment visa. So it is important to understand the purpose of the travel. And when you are considering employing a foreign national, understanding what visa categories they can and cannot use to enter the United States. You should also, of course, understand the expected duration of the timelines that are involved in each of the processes for securing the required visa that they will need, because these can sometimes be pretty extensive. And so if you have an expected start date for employment, it's important that you understand what the processes are involved and, of course, how long they take. You should understand the eligibility criteria to ensure that you are able to sponsor them for the appropriate visa for the purpose of their travel and as well as the purpose of their employment and your expected long-term plans for these employees. And we are going to break everything down. The first half of this presentation will focus on the next slide, please, non-immigrant visas. And those are visas for people who intend to come to the United States on a temporary basis. That means for, let's say, temporary employment or for business meetings or anything that does not involve a long-term permanent intent to remain in the United States. For that, and my colleagues are going to discuss some of the green card or permanent residence options, and those fall under the category of immigrant visa. And so with these two categories in mind, we're going to start with the non-immigrant, again, temporary, and then we will move on to your options for permanent or keeping an employee on a long-term basis. So an overview of what is involved in the application process. Generally, it's a four-step process, excuse me. You will file as a petitioner an application with the Immigration Service under the particular category. Generally, as the sponsor, you will be filing and be responsible for most of the filing fees that are involved in that process. That process can be lengthy. Current processing times are between 4 to 8 months. Some visa categories are eligible for premium processing, which means that you can expedite that process, but it's still a pretty lengthy process. So you need to keep that in mind. Once you received an approval, and that comes in the form of an I-797, you will mail that initial approval to your employee who is at whatever home country they're at, if that's the process they're following. And they will generally take that approval notice to the U.S. consulate, who, after an initial interview, if one is required, will issue them a visa stamp. The employee will then take that visa stamp and go through and enter the United States with that visa stamps, and will be issued an admission document upon entry to the United States. Just a couple things to keep in mind. There are, of course, exceptions to this type of process. Many of them, some of them we're going to cover. For instance, the L1 blanket application. With that type of application, a multinational corporation who has been pre-approved for a blanket can actually send their employees directly to the consulate, so they can skip that first or initial application with the Immigration Service, which can potentially be a significant amount of the adjudication process. So it's important to understand what steps are involved and the timelines involved in each step. Next slide. In terms of application documents, and the documents that you need to be aware is, this is a visa stamp. Most individuals require visa stamps to enter the United States, though not every foreign national does. For instance, Canadians usually do not require visa stamps, and also individuals from 38 visa waiver countries who are nationals of those countries do not require a visa stamp when they are coming to the United States for business or tourism. What's important to understand about this visa stamp is that it is an entry document, okay? So the validity dates let you know when that person can use that document to enter the United States. It does not, though, necessarily provide the individual with status in the United States. For that, we want to move to the next document, and that is the I-94. The I-94 determines how long an individual can remain in the United States after they have been admitted. And this is an admission document. So it's created when the employee enters the United States. An important date, of course, on this document is the admit until date. Not only will that tell the foreign national how long they can be here lawfully, but if they are here in an employment visa category and they have employment incident to that visa status, it also tells them how long they can work in the United States under that status without requiring either an extension or having to depart the United States. Next slide, please. Okay, so another important concept in immigration is employment. All non-citizens require employment authorization to work in the United States. And what is important is, what is the definition of work or employment? It is not defined by the source of the salary. Rather, work is defined by the activity that the foreign national engages in. So the performance of skilled or unskilled labor activities that could or would be performed by a U.S. worker is in fact employment. So basically, if somebody is engaging in activities for which a U.S. worker would expect to be employed in, then that person, that foreign national, is here working and therefore needs employment authorization. Next category. Non-immigrant visas. So as I said initially, we'll give an introduction as to these types of visas today, and we'll talk about the most common ones. There's about 20 different types of visas, and you will recognize that they are temporary and non-immigrant because they start with letters. Next slide. All right, so the first category that we're going to look at is the B1 business visitor visa. And what you have to understand, and if there's something you take away from this presentation, is that the B1 visitor visa is a visitor visa. It is not an employment visa, okay? So some of the qualifying criteria for a B1 is that the foreign national must reside in a foreign country. They must be, if they're coming in for business reasons, be employed abroad. They must be coming in for a specific duration. And of course, they must be coming in to engage in specific and authorized business activities. And we are going to discuss some of those in a little bit. Next slide. As I mentioned earlier, some foreign nationals who are citizens of 38 countries do not require visa stamps to come in for tourism or for business travel. And this is a list of the countries from which people can come in if they are citizens of those countries without requiring a visa stamp. They still have to file an application online, but they don't require a visa stamp. So what are the examples, next slide, of the type of activities that people can come in to do under either the B1 visitor visa or the visa waiver program? And that is to meet with local colleagues, an exchange of information, gain exposure to US markets, consult with business associates. They can come in for training that is not hands-on training, but observational training is perfectly fine. Attending professional or social conferences, and also for pre-assignment activities. So if you have an individual who is coming into the United States, who you're going to be transferring for, but they are currently in the process of getting the appropriate work authorization visa, they can come in to meet the colleagues that they are going to be working in the future. They can come in for house hunting purposes. They cannot, though, come in and engage in work activities, and can certainly not come in while they are under contract with the U.S. employer. Next slide. Type of documentation that a person can bring in to demonstrate their eligibility and confirm their eligibility under the B1 or the visa waiver program is documents such as letters or pocket letters of invitation from a U.S. company for the colleagues, that if you're going to come in and visit with a colleague, you want to have a round trip ticket. You want to have an employment verification document that confirms that you are still and remain employed by your foreign employer. You have to remember that when you are entering, U.S. Customs officers will presume that you are intending here to immigrate, meaning, going back to our initial discussion, to be here on a permanent basis. And therefore, the foreign national has to overcome that presumption by demonstrating to them that they are really coming in for only a temporary intent, and will remain with close ties to their home country and will return to their home country. So if the B1 is not an employment authorized visa, and of course neither is the visa waiver program, because it is in essence the same as the B1, just doesn't require that B1 stamp, then which are the visa categories that are employment authorized? So the first one that we are going to discuss here is the F1. Students under certain circumstances and limited circumstances can work. TN, Canadian and Mexican nationals can work in the United States. The H1B category, which I would say is the most common category for professional employees, and the intercompany transferee, or the L1 visa category. Next slide. So F1 students can work under two circumstances. They can work prior to their graduation if they have secured CPT or curricular practical training. They don't require specific authorization from the Immigration Service, though they do have to be authorized by their school to engage in those curricular practical training type of employment. Next slide. After graduation, after graduation, they can work in the United States pursuant to OPT, or optional practical training, but they do require employment authorization from the Immigration Service. And that comes in two possible forms. So after graduation, they can get a full year of OPT employment authorization. And if they have graduated from a STEM degree program, that's science, technology, engineering, or mathematics, and they are going to be working with an E-Verify employer, then they can also extend that OPT employment authorization time by 2 additional years. Another thing to keep in mind is that F1 OPT employment can also be extended in certain circumstances when the employee is in the process of securing H1B, an H1B visa. And if their employment authorization through the EAD expires after we apply for the H1B, they can in essence work until the start date of their H1B, which is generally October 1. And so they call that the cap gap. Next slide. All right, so TN is the status that is granted to Canadian nationals and Mexican nationals to work in the United States pursuant to the Mexican-Canadian agreement. It used to be NAFTA. What's important here to note is 3 basic concepts. First of all, if Canadians are going to come in to work in TN status, they can actually apply directly at the border and cross over to the United States, or at a port of entry, or at the airport if they are going to go through the airport. They do not need to go to the consulate, and they also don't need pre-approval from the Immigration Service. Mexican nationals do not need pre-approval from the Immigration Service, but they must still go to the U.S. consulate to secure their TN visa, and they require an actual visa stamp in their passport. And once issued, then they can use that visa stamp to enter the United States. And in order to qualify under the TN status, the applicant must be coming in to fill a position that is specifically listed and authorized under the Schedule A provisions of the agreement. And those are generally professional positions, things like engineers, chemists, and some software developers. Next. So TNs are valid for 3 years. You can extend them indefinitely. The spouses of TNs come in under TD, and they are not, authorized to work. And they, of course, have to maintain their ties to the U.S., to their home country, which means that basically they need to, again, continue to intend to return back to their home country. Next slide. Intercompany transferees are visas for individuals who have been working for at least 1 full year for a company that is affiliated to the U.S. sponsor. So for a parent, subsidiary, or affiliated perhaps through common ownership. So if you are part of a multinational group, and you have an employee who has been working for at least 1 full year abroad with another entity in the same group, and you are coming and you're bringing that employee to work in the United States, this is a good option for you. Now, the beneficiary must have been working in the foreign country in an executive or management role, or in a specialized knowledge role for at least 1 full year, and must be coming to the United States to work in either a management executive role or a specialized knowledge role in the United States. Next slide. So L1A visas, as I mentioned, are for executives and managers. So if the foreign nationals come into the U.S. to work as an executive or manager, and they have secured an L1A, they are eligible for a full 7 years of physical presence in the United States. Though the visas are generally approved for an initial period of only 3 years, they can then have two-year extensions. The L1Bs are for those who have been working in a specialized knowledge role and will be working in a specialized knowledge role in the United States. And those are limited to 5 years of physical presence. There is, of course, an exception for those who are spending less than 180 days in the United States. So we have people who have been and continue to work for the Canadian subsidiaries, but sometimes come to the United States on an intermittent basis. They come and work in the United States under the L1, but they don't stay for more than 180 days a year. And so they are not subject to any limitations to their Ls. The dependent category for Ls, in that is their spouses, is an L2, and L2 spouses are now authorized to work incident to their status, which is a great new policy that they are not required to get employment authorization any longer. Next slide. So what does it mean to be an executive or come in to serve in an executive role in the United States? So executives direct the management of the organization. They exercise wide latitude in decision making. They establish the goals and policies of the company, and really just receive very little supervision from the board of directors or executives or higher executives. Managers, on the other hand, next slide, generally manage a department or supervise a function of the organization. If they also generally supervise or direct employees, or if they don't supervise and direct employees, they may be serving in a functional management role where they serve at a senior level within the organization and within the hierarchy of the organization and manage a function of the company. Like I said, they sometimes have authority to hire and fire or recommend for hiring and firing of employees, and the exercise discretion over day-to-day operations of the company. Next slide. So what does it mean to have specialized knowledge? Well, specialized knowledge means that an individual is working in a position where they have gained and utilized expertise regarding the organization's products, services, and equipment, or they have advanced level of knowledge and expertise in the organization's processes and procedures. So what is important is that it is knowledge that is company specific and not industry specific. And so they must come in and be providing expertise that they have acquired by working with the group outside of the United States related to the company's specific products, processes, or procedures. Next slide. H1B is, I would say that the most common of the non-immigrant employment visas. It requires, it is for professionals, i.e. those who will occupy specialty occupations in the United States. And what that means is that the position itself is a position that normally requires a specific academic background, that the employee will be paid at the prevailing wage or actual wage rate, and that the employee possess as at least the US equivalent of a bachelor degree in a related discipline. So my typical example for this type of position is if you are offering an employee, for instance, a position that is a mechanical engineering position, the position itself requires at least a bachelor's degree in mechanical engineering. You will be paying that employee at least the prevailing wage or actual wage that mechanical engineers in that specific county are paid. And then guess what? Your employee has a degree in mechanical engineering or a related degree, let's say in industrial engineering or another related degree. Next slide. H1B provides a total of 6 years of physical presence. And I say physical presence because it's important to note that it's not 6 calendar years. So individuals can, at the end of their time, recapture time, meaning if they have spent time outside of the United States during that 6-year period, they can add it on to the expiration of that 6-year calendar time. And so any time spent outside of the United States can be recaptured. The initial approval is generally for 3 years and another 3-year extension. But because of the requirements that are very specific to H1Bs, if there is a substantial change in the employment of the foreign national and petitions require amendment, let's say that an employee changes their work location from one city to another, that may and most often does change the prevailing wage requirement. That would require a petition to amend. And because of that, oftentimes H1B employees have several H1Bs and are generally not just filing 2 of them. And also because they are eligible for portability, which we will discuss in just a little bit. One more thing to add is that any time in L1 status will count against an employee's total 6 years of H1B time. Next slide. So H1Bs are subject to the cap. Many of you may have heard the H1B Lottery. The H1B Lottery has been instituted because there is often less available visas than there are applicants. There's a total of 65,000 a year, with 20,000 additional for individuals with U.S. master's degrees. So that's why the process for the lottery is established. We start in March. We register, each company registers all the employees that they want to submit to the lottery. After registration closes, the Immigration Service runs the lottery and then advises the employers of the employees that they have registered who have been selected for the lottery. Once selected, the employers have 90 days to submit their application. And once the application is submitted and then approved, it will be approved for no earlier than on October 1 start date. And remember, we talked about that cap gap option, where if you have an F1 student who is filing to change status from F1 into H1B and their EAD employment authorization has ended after filing the H1B, then they can continue working until at least October 1st. Now, there are exceptions to this H1B cap, meaning that there are employers who are not subject to the cap, and there are certain applications, such as physicians who have acquired waivers to the 2-year foreign residency requirement that are not subject to the H1B cap, and employers such as institutions of higher education, nonprofit entities associated with institutions of higher education, nonprofit organizations, and governmental research organizations. There's also an exception available for those who are not employers themselves, who are institutions of higher education, but who have employees who are working at institutions of higher education, and at least the majority of their work must occur at the institution. Next slide. So portability, and I mentioned this earlier, and this is often the reason that H1B employees have several H1Bs. H1B, because there is a cap, a new employer can hire somebody who has already been subject to the cap and has already been selected to work for another employer under the cap, and they can port them to employ at their company. So oftentimes employers use and recruit individuals who have already acquired H1Bs for other employers and can move them into employment with their company fairly quickly. They can start working as of the moment that you file the H1B petition to change employers. You do not need to wait for an approval for you to move an employee over. But you do, of course, have to demonstrate that both the position that is being offered to the employee is an H1B eligible position, and that the employee meets all of the H1B criteria for employment. H1B dependents are H4s. They are generally not eligible for work authorization, except for H1B dependent spouses whose principal applicant or the H1B employee is in the middle of a green card process and has secured an I-140 approval. In that limited circumstance, then their dependent spouse or H4 spouse can work after securing employment authorization from the Immigration Service. And Lori's going to discuss a lot more of the permanent residence options for our foreign nationals. But we are also going to discuss seasonal workers, and Tim is going to share with us a little bit about the seasonal worker option. Thank you.
Yeah, thanks, Anna Maria. Wonderful presentation. And just want to add one additional category that you might want to consider. This doesn't work in all cases. We've been primarily focused on professionals or visas for temporary visas for professionals. This would be primarily temporary visas for non-professionals, although I'm not sure that there's anything that would prohibit you from trying to use this category for professionals. The important thing is that the need for their services must be temporary. So it has to be seasonal, peak load, one time, or intermittent. Much like the H1B category, there is a cap or limit on the number of visas that are available annually. They're divided equally between the summer and the winter season, with 33,000 visas allocated for each. And we have the last few years, there has been additional visas that have been made available, including for the winter season that we're currently in. An additional 20,000 visas were just made available. There actually is a bipartisan proposal or letter asking USCIS and the Department of Labor to increase the supplemental visas by 45,000 visas this year. We'll just have to see, but that's 66,000 visas, not many for the entire country. And there's also a prevailing wage requirement. And unlike any of the other categories that we've been discussing, there's also a labor market test that is required, which is where you must prove that there's no qualified US workers that are available and that want the job. All right, so Lori, we've just had this wonderful overview of these non-immigrant visa options, and for the participants, what we would like to do is now maybe just kind of personalize this a little bit and give you a frame of reference for how this would apply. So we're going to start with we have 3 case studies. You'll get familiar with all 3 of these in the context of temporary as well as permanent. So we're going to start with Ganesh. Ganesh was born in India, will graduate from Drake University on May 15th with a master's degree in computer science. He is an F1 student, expects to receive an employment authorization document under optional practical training in time to begin working for your company as a senior software quality assurance engineer. After graduating with a bachelor's degree from Bangalore University, Ganesh worked for 5 years for a software developer. And here's where the variation comes in. We're going to alter the country where he worked, and then decided to pursue an advanced degree at a university in the United States. So our initial variation is going to be that he worked for 5 years for a company in India. Lori, what are the options?
Thanks, Tim. So Ganesh would qualify. He's going to have OPT for 12 months if he joins your company right away. And because he was in a STEM field, the computer science is a STEM field, he would qualify for a 2-year extension of that OPT under the STEM OPT if Drake University uses, which is in Des Moines, in my hometown, or my town right now, by the way. If Drake University uses E-Verify. So if you're an E-Verify employer, you can get that 2 additional years of STEM OPT. But he would also qualify for the H1B, and he would be subject, well, for Drake University, he would not be subject to the cap because it's a college or university, so they are exempt from the H1B cap. But if it was a private employer, you would have to think about the H1B cap, the numerical limitation Anna told you about, and you would want to start doing that right away, register the first time you could, even though he had 2 more years potentially left on the STEM OPT, because you just don't know. It's random lottery, and usually there's 3 times more people apply than visas are available. So that would be if he's from India and has Indian citizenship only, that's what he's got, Tim. How about with these other variations, though?
So we're going to mix this up a little bit. He goes and instead of working in India, he works in Chile or Singapore, and he works there for 5 years, and he becomes a U.S. citizen, or excuse me, becomes a citizen of either Chile or Singapore. What option becomes available? Well, he would qualify for this H1B1. Not ideal, but if he's not been selected in the H1B lottery, it may be a way to further bridge the gap between the STEM OPT extension and when he's able to start working on H1B. He went to Australia there for 5 years and then became an Australian citizen. Then that would open up the category E3, which is available for Australian nationals, professionals. The criteria is very similar to that of the H1B. He could be in the United States in 2-year increments and for an indefinite period of time. Now, if he went to Mexico or to Canada, became a Mexican or Canadian citizen, then that would open up the possibility of the TN visa category, likely as a computer systems analyst. Anything else you can think of on that?
No, I think that's good for Ganesh.
We covered those. That's very good. So now let's meet our second case study, which is Monica. Monica is a German citizen, has risen through the ranks of your company's German parent company, and for the past 2 years has been the Global Chief Technology Officer. Your company is about to undertake a major expansion at its headquarters in Pittsburgh, and Monica has been appointed to be the U.S. company's new CEO and oversee this very important expansion. You anticipate that Monica will be in the United States for at least 5 years, with the possibility that she could remain here permanently if things work out for her and the company. Well, this is a classic L1A job. Monica has been an executive in Germany. She's worked there for at least 1 year in the previous 3 years. The companies are appropriately related, and she's coming here to the United States to become the CEO of the expanding US company. She clearly would qualify for L1A. Now, let's change this just a little bit. And let's say that rather than being an executive, she's just, has been an important part of developing the technology of your company upon which this entire multinational corporation is based. So she's not an executive, she's not a manager, but she has played this critical role of being the original or principal developer of the technology. Lori, what are the options?
Well, we'd first look at L1B because we do have that affiliation, and we'd need to see if this would be a job both both her job at the foreign affiliate and the job we're offering in the States would qualify as a job involving specialized knowledge. Now, just one quick note that you can mix and match. Someone could be a manager abroad and be coming here as specialized knowledge or vice versa. But we would look at that. We could also, and just note that the specialized knowledge definition is not very intuitive. So it's something you really have to dig into and get with your immigration lawyer to understand. But also we could look at O1 potentially, which is something we didn't talk about, but there is extraordinary ability, worker potential. There might be some other options for her, but L1B would be my first look for her.
And just in the same vein, we didn't talk about this, but the E1 or the E2 category is another set of visas that multinational corporations could look at that Monica may qualify for.
Yeah, potentially, that's right. So let's turn over to our third scenario for Orlando. Orlando is from Cancun, where he has worked for several years in the resorts as a server, busser, kitchen assistant, and other positions that don't really require education or experience. But he's learned about this great opportunity to come work temporarily for your company in the United States, which owns a large ski resort in Tim City of Park City, Utah. So he will work for your company during the winter season, and then he'll work for another large resort owned by another company in Sun Valley, Idaho during the summer season. His positions at these resorts will be similar to what he did in Cancun. So Tim, can you help Orlando?
Yeah. So this is going to be kind of the classic H2B scenario. We have a temporary, actually called peak load need is what this one would fall under. And you don't need them for the entire year. You just need them for the season, but we call it peak load because you employ these types of workers year round. There's just a period of the year that you need more. So H2B for Orlando.
Great. Okay, well, we're going to turn to permanent residence. Since we're kind of short in time, I'm going to make it a real quick breeze through it. But just to let you know that the permanent residence is what you hear about the green card. It allows someone to stay and work in the U.S. In fact, they don't even have to work after someone gets a green card. They're not tied to your company anymore after they get the green card, as long as it was a legitimate job offer and they did really work for your company. They could move on later. And permanent residence isn't really permanent because it can be lost through either committing certain crimes or spending too much time outside the U.S. But if you do stay a permanent resident for 5 years in most situations, you can then apply for U.S. citizenship if you meet the qualifications. So next slide, Tim. Most people have to go through this process called PERM or labor certification that is made by the Department of Labor to protect the U.S. Labor force. It requires, like the H2B, but a little more intense process, requires a labor market test where you follow the Department of Labor rules to advertise the job, to only use the basic minimum requirements for the job. You basically just have to go with what Department of Labor is asking you to do and not try to make a lot of sense of it, because they're very strict rules that they have crafted to protect U.S. workers. Now, this process is pretty long because Department of Labor, for one thing, wants to make sure that we have the right wage being offered for the job, and they have to pass on that wage. And that process itself can take, now it's taking like 5 months or more, just for the wage. And then you have to advertise in certain places at certain times. You have to go with, your state workforce development agency, internal postings, newspaper ads, which people don't use too much anymore, but we still have to use for this process. And then it's filed online, and Department of Labor then takes another several months, depending on their workload, to look through this online application. And if they want to see all your documents that you've accumulated for this process, they can audit the case and make you send all those documents in, which will then take even longer for them to look at your look at everything before they decide if you have appropriately tested the labor market and shown there's not a U.S. worker available for the job. Now, if you've accomplished that, then you can go to the U.S. Citizenship and Immigration Service and file another form called an I-140 that says we're offering this job that we tested and we're offering it to this person who is qualified, and we have the ability to pay the wage that we're offering to the person who's probably here working for you in this temporary status. Now, you don't have to hire someone who you might find who's qualified in that process, but it would mean the process would stop and you'd have to start over or not, or abandon the chance for permanent residence if you found someone who was qualified in that process. But if you don't, you go on and you file this I-140. Now, what happens next really depends on the waiting line. And so let's go to the next slide and look at the waiting line. So the Department of State, another agency, actually determines every month this waiting line. This is for February. And you'll see there's these categories and these countries. And what we're talking about here is that we have only 140 immigrant visas available each year for all the jobs in the United States. And those are divided by country, and then they're also divided by category. The categories relate to what is required for the job in terms of education, training, and experience, and also whether they meet certain special categories that we'll touch on in a minute. But if you went through the PERM process, you're in either the second or third category, which is determined based on the education required for the job. So the second requires either a master's degree or higher, or a bachelor's degree plus 5 years experience. And then the third category and the other workers, which is a subset of the third, is lesser education or experience. So we see on this chart a lot of C's, and the C means current, which means there's not a waiting line, which is great. But then we'll see in, China, India, and then for those two categories, just China and India, we'll see some dates. And what those dates mean is that you had to have filed that first step of your process, in this case, the PERM, before the date listed for your employee to apply for the final step in the green card process in February 2022. So if we're looking at a master's degree job for someone from India, we're looking at a person who in February 2022, the person to be able to apply for the final step of the green card, they would have had, the PERM would have had to have been filed for them before January 1, 2013. So that's what they're talking about in that. So you can see there's quite a waiting line. So for someone from India or China, they're going to be stuck with that approved I-140 and just waiting for their date to come up. And during that time, they're going to have to maintain some non-immigrant status, like Anna Maria talked about, which is why the H1B is so popular, because the H1B, if you file your PERM in time, or if you get your I-140 approved in time, you can continue your H1B status past this 6 years and keep going in that basically indefinitely until now you have to keep filing renewals. So there's going to be work involved, but you can keep someone in that status while they're waiting for their green card. Now, if you've got someone in L, you don't have that option, and we're going to have to get creative of how we bridge this gap. Fortunately, there's some alternative to PERM. So let's see that next slide there, Tim. So there's I mentioned those other categories have there's some special categories and different ways to get there. The first category has extraordinary ability, outstanding professors and researchers, and also which for some reason I don't have on here, but it exists, which is the international executives and managers. And so if you have an employee that can meet one of those categories, there's no waiting line right now for any country for those categories. So, extraordinary ability is kind of, you don't have to have won a Nobel Prize, but you do have to be really good. Outstanding professors and researchers, it's a little lesser standard, but still a lot of accomplishment, and a job offer from either a research institution or a private company that engages in research and has research accomplishments and has at least 3 other employees involved in research. So you can do that for a private company. And then the international executives or managers is kind of like the L1A, but you can't mix and match. They have to have been L1A sort of qualified in their foreign country, and then L1A here. And the specific company they worked for has to continue to exist. So that would be one way to get someone here quicker. There's also some other things that allow you to skip the PERM if Department of Labor has considered you to be not requiring the PERM. So that would be RNs and physical therapists, or employees with what they call exceptional ability, which is yet another way to measure accomplishment in certain fields, basically any field where you can get a college degree. Next slide, please. We can also exempt physicians who are serving in underserved areas. We also have what's called a national interest waiver for people who are serving the national interest. They can waive the PERM requirement, and those are there. I list the requirements there. And then there's these entrepreneurs, which we won't even go into now, but just so you know, they exist. Next slide, please. So this is where you enter your code. And if you are from New York, New Jersey, Pennsylvania, or Kansas, you must type in the code WINTER in the Q&A section at the right-hand side of your web app screen. Please be sure to hit the send button so that it registers, and the code is WINTER. Okay. Next slide, please. All right, then there's a few non-employment options, and that includes marriage to a U.S. citizen, marriage to someone who already has a green card, being sponsored by a permanent resident or U.S. citizen parent, being sponsored by your U.S. citizen sibling, or your U.S. citizen child who has achieved over 21 years of age. Now, there are waiting lines in these categories that I've put an asterisk there, and we'll just show you those really quick in the next slide, which you can see here many more dates, many longer waiting lines in the family-based categories. But just so you know, they're there. Okay, next slide, please. And just a couple of considerations before we go to our examples to kind of bring this home. Anna Maria mentioned intent quite a bit in her presentation, and we do have to be concerned when someone's in a non-immigrant status, a temporary status, and then they're trying to get their green card. Their intent is going to be assessed if they leave the U.S. and they come back, or if they file for an extension of stay. Now, if someone's in the H or the L, they have dual intent, which means they can have both immigrant and non-immigrant intent at the same time. So they're not really in much danger here. But if you're dealing with someone on TN, for example, you've always got to manage that timing very carefully, because depending on when they would go to Canada or Mexico, it's possible that, if they've already got an I-140 approved, then they potentially wouldn't get back in on a TN because, they have the intent to immigrate. Also, if you get to the point where you've filed your last step in the green card process, after that waiting line, or if there's no waiting line, you file this final step with the Immigration Service, you will abandon that step if you leave and you don't have either an H or L visa, or you've been granted permission to leave by the Immigration Service. So you can't just pop over to Canada after you filed your green card. We also have to worry about sometimes about job changes during the wait, particularly the long waiting lines. In reality, people change jobs, they promoted, they go to different companies, and the green card process doesn't always follow them. And we have to always assess that and see if a job change would mean we would have to do that process over again, or if a new employer would have to do that process. The final consideration is that we always get these questions about reimbursement of costs. And so, as we mentioned with the temporary visas, usually it's going to be the employer who has to pay the cost. Some of that is regulated, some isn't. Some categories aren't. In the green card process, if you're dealing with Department of Labor, you're going to have to pay the costs of that part of the process. When you get out of the Department of Labor realm, you could have the employees share those costs. And in fact, some of these, like extraordinary ability or the national interest waiver, people don't even need an employer. They can file on their own and they can pay it on their own. Even if they're working for you, they could actually fund it themselves and get this non-employer required green card application approved. So something to check, and getting a reimbursement agreement is a very tricky thing. We can certainly talk about that, but a lot of times that's a very tough thing to do as well. So Tim, let's go back to our examples and see where we are with that.
Right. Yep, so we're back to Ganesh. And for purposes of our discussion, we're going to say that he went to Australia. He was there for 5 years, didn't become a citizen, but he did get married to an Australian citizen, someone who was born in Australia. So, Lori,
so
what are
he
the
could do
options?
Absolutely. He could do a PERM. That would be the normal. Now he's working for a university, and there's a special rule for PERMs for college and university teachers, but under these facts, he's not teaching. But if he was teaching, there's actually a quicker, nicer PERM that you can do called special handling. And he could potentially, depending on how great he is at what he does, he's got a master's and 5 years experience, so maybe he has a lot of accomplishments. We could look at some PERM alternatives. But Tim, with that, marrying someone from Australia, why is that in the scenario? What does that do for us?
Yeah, so we've got this wonderful provision in the immigration laws called cross-chargeability. And so Ganesh, who was born in India, normally would be under EB2 or EB3 India. That would be his category because that's his country of birth. But if he marries a citizen of a country other than from India or China, who is part of what I'll just call the rest of world category, then he gets to be treated as if he were born in the spouse's home country. And as Lori has shown in the visa availability, it's a much shorter wait if we can look at, or if he can get a green card under rest of world rather than from India. So cross-chargeability is a wonderful opportunity when it arises. We're going to go back to
and
Monica.
I will say just one thing really quick about that. Before, when we were talking about if he got citizenship of one of those countries, if he could get different visas, citizenship doesn't help you get out of the waiting line. It's where you're born. So even if he'd gained Australian citizenship, couldn't get out of the waiting line, only if he married somebody, right, Tim?
Yep, it's always, immigrant visa availability is always based on country of birth unless there is cross-chargeability. All right, so back to Monica. So she comes in under, if she's the executive, she's here under L1A, and there is this wonderful corresponding green card category called the multinational executive or manager category. The requirements are identical to those of the L1A visa category, and generally, if someone qualifies for L1A, they will also qualify for this particular visa category. Unfortunately, if she's in L1B, even if she is now working as an executive in the United States, she's not going to qualify for the multinational executive or manager category. She has to have worked as an executive or manager abroad in addition to in the United States. So if she's in L1B, then we would look at EB2, EB3, following the PERM options. However, perhaps given her role in the development of the technology of this company, perhaps she would qualify for one of the PERM alternatives. What do you think, Lori?
Yeah, you know that if she developed this really great technology, there's all kinds of things. There's national interest waiver, which they just put in the policy guidance that STEM occupation, STEM fields and work in STEM can be national interest waiver qualified, so to speak. So we could maybe skip PERM. Maybe she qualifies as, you know, a researcher potentially, depending on what the company is, or extraordinary ability. So she's got a lot of options. But she also has a non-employment option if she would marry with Jessica. We do have a marriage-based option there. Now we're, you know, if they're not going to marry, we're not going to force them to marry as the employer, obviously, but it would be something that she could do. And the federal government does recognize same-sex marriage as a basis for immigration, so that would potentially work there. And Tim, I think we're just about out of time, but can you tell us real quick, can we get Orlando from H1B to green card?
Absolutely can. We just have to be really careful to make sure we distinguish between the position that he held in H1B and the position that we're going to seek the employment-based green card for. As long as those two are different, we should be able to help him get across the finish line. And we just got across the finish line, and it has been wonderful to be with all of you today. We hope this has been an informative hour learning about these options for ways that you can augment your workforce with foreign workers. Thank you for the opportunity to share this with you. And also thank you to Ana Maria and Lori. Amazing experience to be able to work with you on this panel. Thank you all.
You as well, Tim. Thank you. Thank you all.
Thank you.
Well, thanks, guys, and thank you for finishing on time. Welcome to all the participants. I'm David Kornblau. I'm a partner in Denton's New York office and have been handling securities enforcement matters for, I'm afraid to say, over 3 decades, including 10 years in the SEC's enforcement division, where I served as nationwide head of litigation. At Denton's, I help financial institutions, public companies, and their personnel protect themselves when faced with complex investigations by the SEC, CFTC, other regulators, and law enforcement. Today, I'll be discussing the state of SEC enforcement in several key areas with a look ahead to the rest of the year. With me today is Alyssa Landau, a litigation associate here with me in Denton's New York office. Alyssa helped me put together today's presentation. And she'll be watching the chat, which I hope you will use to, in addition to getting your CLE credit when I give you the code, but throw out some comments, questions as I'm going. I'll pause occasionally to see if there are any questions out there that Alyssa will bring to my attention, and hope to have a bit of a dialogue with the group. So let us get started here with the slides. And it has now been 10 months since Gary Gensler took office as SEC chair, and over 7 months since Gurbir Grewal became director of the enforcement division. Both appointments heralded a more aggressive approach to SEC enforcement than we saw under the previous administration. Mr. Gensler had been chair of the CFTC in the Obama administration, where he became known for ramping up the CFTC's enforcement program, especially targeting Wall Street. And Mr. Grewal is a career prosecutor who had been the New Jersey Attorney General and previously headed the Economic Crimes Unit in the U.S. Attorney's Office for the District of New Jersey. He was widely expected to join Chair Gensler in beefing up enforcement at the SEC. And Mr. Grewal, after he came to the agency, named as his deputy Sanjay Wadhwa, a long-time supervisor in the SEC's New York regional office with a reputation as a very tough enforcer. So the big question for today is, what has the new leadership achieved so far in the enforcement arena? Now, most investigations take at least 6 months and frequently a year or more. So for the most part, the enforcement actions we've seen from the current administration most likely arose from investigations that began before the new leadership took office. We should expect to see the results of investigations begun under the current regime in the months ahead and later in the year. Still, the administration can and has revealed changes in its approach with matters that were already in the pipeline when they took charge. Today, we'll take a look at what the SEC has accomplished in 7 key areas listed on the slide: sanctions and cooperation, ESG, SPACs, crypto and DeFi technology, meme stocks and trading apps, accounting and financial disclosure, and whistleblowers. Let's start with sanctions, SEC sanctions, where the agency has already started making some significant changes. Last fall, Mr. Gensler, Mr. Graywall, and Mr. Wadwell all made public remarks describing their approach to sanctions. Mr. Graywall hinted that the agency would seek higher civil penalties, particularly where comparable conduct by others was punished previously, or where a company is deemed a recidivist because it committed prior violations, even for unrelated conduct. The new administration also signaled a return to the Obama-era practice of requiring admissions in some, but not all, settlements. Admissions are a departure from the SEC's general practice of allowing defendants to settle enforcement actions without admitting or denying the SEC's allegations. In the Obama era, defense counsel were often frustrated by the unpredictability of when the SEC would require admissions. Mr. Graywall said that admissions would now be required in cases where, and this was his quote, heightened accountability and acceptance of responsibility are in the public interest, close quote. So that's a bit general, a bit vague. Mr. Wadwa, the deputy, elaborated, gave some more meat to that standard. And he said that admissions would be sought in cases involving what he called egregious misconduct, where a large number of investors were harmed, or where the SEC's investigation was obstructed. Well, that standard would seem most applicable to SEC actions alleging materially false statements by public companies, where there's a lot of public investors, or offering frauds, or cases where there's evidence that of spoliation or witness tampering. In addition to admissions, Mr. Graywall emphasized officer and director bars, conduct-based injunctions, undertakings that limit a company's activities, functions, or operations, and independent compliance consultants. Now, those remedies have long been in the SEC's toolbox. And just to give you one example, back in 2018, under the prior SEC administration, you may remember the SEC entered into a well-publicized settlement with Tesla and Elon Musk that included several undertakings, such as requiring that Mr. Musk resign as chairman, having him replaced with an independent chairman, and requiring the company to take steps to oversee Mr. Musk's tweets and other public communications about the company. So speeches and other public statements by SEC officials can be helpful, can give some insight, But the most meaningful insights come from what the SEC actually does in real enforcement actions. And there have been a couple that have begun to flesh out the agency's approach to remedies. In December, the SEC announced a settlement with JP Morgan Securities, which involved the failure by the bank's broker-dealer subsidiary to preserve business communications of its personnel using unapproved apps on their personal devices. The SEC found that JP Morgan had given incomplete responses to a number of prior SEC document requests because the firm had not collected or produced relevant communications on personal devices. The SEC did not say whether any of those omitted communications reflected wrongdoing or would have changed any of the staff's conclusions in those prior investigations. The most significant aspect of the JP Morgan settlement was the size of the penalty. JP Morgan paid $125 million to the SEC, plus another $75 million to the CFTC for the same or similar issue, record-keeping issue. The SEC's penalty is extremely high by historical standards, especially for a pure books and records case with no allegation of fraud or customer harm. Traditionally, books and records violations would generally be viewed as on the less serious end of the range of violations alleged in SEC enforcement actions. In fact, under prior administrations, penalties against broker-dealers for pure record-keeping violations typically were in the 6 figures or low 7 figures. So the SEC's $125 million penalty against JP Morgan therefore appears to be in the neighborhood of 100 times higher than it would have been expected in the past. That is an extraordinary increase. And interestingly, the SEC did not try to justify that whopping penalty by portraying JP Morgan as a recidivist, even though, like all of the large Wall Street banks, JP Morgan has settled multiple SEC enforcement actions over the years. It remains to be seen whether the SEC will apply a comparable increase in other types of cases. If so, we could start to see billion-dollar SEC settlements in fraud cases against large banks and companies in other industries, and many more settlements in the 8 or 9 figures in what you could view as even more routine SEC cases. With that much at stake, some companies may decide to litigate weak or marginal cases with the SEC, when in the past they might have settled in order to avoid a public battle with a regulator and the distraction and cost of litigation. On top of the large penalty, the SEC also required JP Morgan to retain a compliance consultant and implement the consultant's recommendations to enhance the firm's policies and systems for preservation of electronic communications. Now, the SEC has required compliance consultants in many cases, settlements over the years, but what's notable in this case is that the SEC acknowledged that JP Morgan had already implemented significant remedial measures before the SEC took action. In that type of case, the SEC previously often did not require an outside consultant, and instead, the SEC might have had the firm report to the SEC staff on the changes that it implemented and certify compliance over a period of time. So based on this JP Morgan settlement, we may see compliance consultants becoming much more common in SEC settlements with broker-dealers and potentially public companies as well. While this would be welcome news for the consulting industry, it is problematic for companies. In my experience, outside consultants can sometimes take a very broad view of their mandate to dictate changes within a company. And their views and recommendations can become a significant burden, distraction, and expense to the company. So finally, on this JP Morgan settlement, it's also notable in that the SEC required JP Morgan to admit the relevant facts and to acknowledge that its conduct violated the federal securities laws. This is the first settlement under the current SEC regime with an admission. The SEC justified its requiring of an admission by arguing that JP Morgan's actions had, quote, meaningfully impacted the SEC's ability to investigate potential violations of the federal securities laws. That concept, obstruction or a lesser form of obstruction, fits within the agency's prior statements about one of the types of cases where an admission would be sought. But since Mr. Graywall spoke publicly about admissions in the fall, the agency has brought a dozen or so other settled enforcement actions, which did not include any admission of wrongdoing. Several of those actions allege securities fraud. So you might ask, why does a books and records warrant an admission, but fraud cases didn't? In any event, companies may find it easier to agree to an admission in a books and records case because there's no private right of action for that type of violation. That means that the admission does not create potential civil litigation exposure. Companies are generally more concerned about admitting to a fraud, which could have serious collateral consequences, including potentially criminal investigation, as well as civil litigation. So on the topic of admissions in SEC settlements, I suspect we're going to see a repeat of the unpredictability that we saw in this area when it was used in the Obama administration, and particularly if the SEC demands dramatically higher penalties along with an admission of wrongdoing, we may see more companies refusing to settle and putting the SEC to its proof in court. All right, a related topic is credit for cooperation. A common strategy in SEC matters is for a company to seek to avoid charges or to win reduced sanctions based on its cooperation with the staff's investigation. 2.5 weeks ago, the SEC used the announcement of a settlement to provide some guidance on the agency's current view on cooperation and remediation. In that case, the SEC alleged that a private tech company called Headspin and its former CEO had engaged in a fraudulent scheme. The allegation was that the company had deceived investors by inflating the company's valuation in 2 funding rounds. Now, despite the seriousness of those allegations, the SEC did not assess a penalty against the company. The SEC allowed Headspin to settle with no admission of wrongdoing and with only an injunction against engaging in securities fraud again in the future. How did Headspin get such a sweet deal, you may ask, you may wonder. In the SEC's press release announcing the settlement, Mr. Graywall credited the company's remediation and cooperation, which included an internal investigation by the company's board, removal of the former CEO, a revision of the company's valuation, improvements to its governance procedures, and repayments to allegedly harmed investors. The SEC called this case an excellent example for companies wondering what types of remedial actions and cooperation might be credited by the Commission after a company discovers fraud. In my view, this case raises more questions than it answers. Headspin's extensive cooperation and remediation would most likely have spared a company from paying a penalty to the SEC ever since the agency announced its cooperation policy in the so-called Seaboard Report over 20 years ago. Is the SEC now saying that the staff would view as inadequate any cooperation short of what Headspin did? I'd say that's unclear. Paradoxically, it can be easier for companies to meet the pretty high Headspin standard for cooperation when the company has engaged in the most egregious clear-cut type of fraud. In those situations, a board may decide to self-report, terminate responsible senior management, repay victims, revamp governance processes, because it may conclude that ultimately it would be forced to take all those steps anyway. So the board might as well try to get credit for taking those actions quickly and voluntarily. The tougher cases are where conduct falls in a grayer area, and it's not clear within a company who bears responsibility for it. The SEC hasn't provided guidance for that more typical fact pattern, which requires a great deal of judgment and experience to navigate through the SEC investigative process efficiently. Don't see any questions in the chat, but feel free to fire away. So we're now going to shift gears from SEC, the investigative process, to some of the priority substantive areas of focus of the SEC. And a good place to start is ESG, or as everyone knows, corporate environmental, social, and governance issues. ESG is currently dominating the agendas of corporate boards, funds, and government agencies like never before. ESG has become an industry unto itself. The scope of ESG keeps growing, as you can see in this slide that we put up here. It includes issues relating to climate change, pollution, but also diversity and inclusion, sexual harassment, cybersecurity, corruption, and much, much more. The SEC's focus on ESG centers on disclosure, and the SEC is still expected to propose new rules mandating ESG-related disclosures, presumably in the early part of the year, but no one really knows when they're going to come out. Nearly a year ago, and that was a month before Chair Gensler took office, the agency announced a 22-person climate and ESG task force in the enforcement division. The mission of the task force is to use data analysis to identify ESG-related misconduct proactively. But unless and until new ESG rules take effect at some time in the future, which we don't know, any SEC enforcement actions, by definition, would have to be based on a violation of existing anti-fraud or other disclosure requirements that the SEC enforces. The task force is looking for material gaps or misstatements in issuers' disclosure of climate risks, as well as any disclosure or compliance issues relating to investment advisors and funds' ESG strategies. Current securities law does not define or establish a metric or a standard to assess generic statements of greenness or sustainability by companies or funds. So I think, yes, the enforcement division's focus currently is likely to be what I would call traditional fraud or disclosure theories based on allegedly misleading statements involving objectively ascertainable facts or inadequate risk disclosures. In other words, the Enforcement Division will be on the lookout for classic fraud or disclosure cases that it can shoehorn into an ESG-related message. For example, back in September 2020, under the prior administration, the agency brought an action against Fiat Chrysler, alleging that it had made misleading statements about an internal audit finding that its vehicles complied with emissions regulations. And shortly after the ESG task force was established last year, the SEC charged Under Armour with making misleading statements concerning its future revenue prospects. Should be more of a traditional accounting disclosure type of case. But in its announcement of the case, the SEC emphasized the company's, as an alleged motive, that warm winter weather was depressing sales of the company's cold weather apparel, ergo an ESG case. Given the SEC's eagerness to bring ESG-related enforcement actions, all companies should know that they need to be scrupulous about their ESG-related disclosures. I think that's well known, that's a given. I would take it a step further for companies in certain areas like energy-related companies, ESG-themed funds. Those are going to be natural targets for the SEC's focus. So those firms should be extra conservative with all of their disclosures, even if they don't relate directly to ESG. No company wants to be the SEC's next ESG poster child. Next topic, SPACs. Special purpose acquisition companies. An old idea that became newly hot a couple of years ago, as you can see in the chart. They used to be called blank check companies. The basic idea of a SPAC is to use an IPO to create a listed public company whose sole purpose is to merge with or acquire an as yet unidentified private company within a fixed period of time, typically 2 years. SPACs generally raise additional funds from institutional investors through a PIPE offering. Sometimes celebrities or well-known investors sponsor the SPAC and receive promotional shares. SPAC shareholders typically pay $10 per share and have the right to get their money back anytime until the acquisition or merger occurs. The SPAC merger or acquisition is called a de-SPAC. If no de-SPAC occurs in the required time frame, the SPAC is liquidated and the money is returned to investors. If the SPAC finds an acquisition target or merger target, it typically raises additional funds privately from institutional investors, and the SPAC shareholders can decide whether to redeem their shares or become shareholders in the merged entity. The merged entity replaces the SPAC as a public company trading on a stock exchange. So in effect, the private company goes public without having to go through the traditional IPO process and without some of the restrictions that apply to IPOs, such as a prohibition on financial projections. As you can see from the chart, the amount raised in SPAC IPOs surged in 2020 and then doubled about in 2021. When Chair Gensler took office last year, he and other SEC officials expressed concerns about the quality of disclosure in connection with de-SPACs and indicated that the enforcement staff was focused on the issue. The SEC has brought enforcement actions relating to de-SPACs of 3 companies: Akazu, a music streaming company; Momentous, a space technology company, and Nikola, a truck manufacturing company. For the most part, these actions look like standard SEC securities fraud cases alleging various false and misleading disclosures by the companies and their senior management. In Akazoo, the claim, the SEC's claim was that the company said it was growing and successful in its music streaming business when in fact it had no paying users and only negligible revenue. In Momentus, the SEC alleged that its CEO made misrepresentations about testing of the company's technology and some national security concerns, alleged national security concerns about the CEO. Nikola and its CEO were charged with making false statements about the company's products, trucks, and related products, and technological advancements. So fairly standard stuff. But the most significant of these actions is Momentus, that case. In addition to charging Momentus and its CEO, the SEC also sued the SPAC and a SPAC sponsor, even though the SPAC and the sponsor could be viewed as victims of the alleged misrepresentations made by Momentus, the company that the SPAC was acquiring. The SEC alleged that the SPAC and the SPAC sponsor failed to conduct adequate due diligence in the de-SPAC and charged them with negligence-based securities fraud because of allegedly inadequate due diligence. And Chair Gensler was quoted in the SEC's press release in the case, which is not standard for enforcement division announcements to have the chair make a statement. And so he included a statement in which he highlighted the SPAC's liability, even though, and he used the word lie, even though it was lied to by the company it was acquiring. The other notable aspect of the Momentus case is that the SEC brought the case before the de-SPAC closed and required in the settlement that the PIPE investors be notified of their right to recoup their investments before the deal closed. So an interesting after phenomenon of the Momentus case was that the market did not seem to be particularly impressed with the SEC's fraud allegations. About a month after the SEC announced the case, announced the settlement, announced the fraud allegations, the alleged failure of due diligence, shareholders voted on the transaction that had not yet closed. And in fact, public shareholders of the SPAC approved it. And only about 20% of the shares were redeemed. So the SPAC shareholders, for the most part, didn't redeem their shares, stayed in the deal, and PIPE investors contributed $110 million to the new public company. So, you could ask, what did the SEC achieve in that case? Who were they protecting? I expect to see additional SEC enforcement actions targeting de-SPACs. According to a Wall Street Journal article came out a few weeks ago, share prices of half the companies that completed de-SPACs in the past 2 years are down 40% or more. A number of companies are even pulling out of previously announced SPAC mergers, even though that can trigger substantial payments to the SPACs, or punitive payments. These trends surely have not escaped the SEC's notice, and enforcement staff, I think, are no doubt scrutinizing the disclosures made at the time of de-SPAC transactions by companies that are now struggling or failing. And in light of Chair Gensler's comments on the Momentus settlement, I would expect the staff also to be assessing the quality of due diligence performed by SPACs leading up to the de-SPAC combinations. that later perform poorly. Defense counsel will have our hands full in these cases. As always, the SEC enforcement staff will look at the facts with perfect 2020 hindsight. But of course, there is nothing inherently fraudulent about a company that underperforms, and reasonable due diligence will not identify every potential problem facing a company. Materiality, I think, will also be an important battleground in these investigations. As the Momentous case shows rather dramatically, facts that the SEC staff deems material in an investigation may or may not actually be important to actual investors who are reviewing and voting on transactions. All right. I see the chat is quiet, so we are going to barrel forward onto our next topic. Another hot one, I'm sure folks have been reading about for a long time now, is crypto. And more recently, crypto is often come up in the context of so-called decentralized finance technology, or DeFi. It's now been 4.5 years since the SEC issued the so-called DAO report, DAO report, staking out a very broad definition of a security in the context of cryptocurrencies, and that's what gives the SEC jurisdiction. The crux of the issue is how to apply to cutting-edge digital assets the standard announced by the Supreme Court in 1946 in SEC v. Howey, a case involving not cutting-edge technology, but interests in orange groves. The Howey standard defines a type of security known as an investment contract, and it defines it as a transaction or a scheme for the investment of money in a common enterprise with the expectation of profits from the efforts of others. Relatively few words which have spawned quite a bit of debate and confusion, frankly. Since the DAO report was issued in 2017, the SEC has found that the definition of security encompasses virtually every type of digital asset, except Bitcoin and Ether. Those were the earliest cryptocurrencies, and those were exempted by the SEC from the definition because their use had become so widespread and decentralized that they could no longer be deemed to involve an expectation of profit from the efforts of others under the Howey standard. More recently, the SEC has ceded jurisdiction to the CFTC over another type of digital asset known as stablecoins. These are blockchain-based assets tied to the value of traditional government-issued so-called fiat currency, regular money. So the regulators now view stablecoins as commodities rather than securities, and the CFTC, at least for now, gets to regulate those. Based on its broad definition of security, the SEC has for years now brought numerous actions targeting a variety of different types of conduct touching digital assets. And that activity, that enforcement activity by the SEC will likely accelerate under current SEC leadership. Most of the prior actions, particularly going back to last year and before, involve so-called initial coin offerings, or ICOs or ICOs. The SEC likened ICOs to stock IPOs. But there are significant differences between them. Most notably, there are a lot of differences, but most notably and fundamentally, purchasers of digital coins, digital assets, typically have no ownership interest in a business. Nonetheless, the SEC has argued that they almost invariably fit within the Howey definition and has charged ICO promoters with engaging in unregistered securities offerings. It's Section 5 of the 33 Act. If the SEC found material misstatements by the promoters involving the ICOs, the digital assets, the promoters were also charged with securities fraud. More recently, the SEC has gone beyond ICOs in its crypto enforcement actions. The agency has brought actions against a developer of a purported crypto trading app, that was called the Tele app, an online digital asset exchange called Poloniex, and a website that profiled various digital coins, coinschedule.com. As I mentioned, the SEC's newest crypto focus is on DeFi, decentralized finance. DeFi is technology that offers traditional banking products, or what we would typically think of as traditional banking products, such as loans, savings accounts, on the Ethereum blockchain. So, for example, last August, the SEC brought an enforcement action that shut down a program called DeFi Money Market. That one paid a fixed rate of interest on digital assets lent to the program via smart contracts on the blockchain. The SEC alleged that the program misrepresented how the interest was generated. Last September, another action, the SEC and DOJ, the Southern District U.S. Attorney's Office, brought charges involving BitConnect. That was a crypto lending program. It raised over $2 billion in Bitcoin. According to the government, it promised outsized returns that would be generated by a crypto trading bot, but allegedly it was just a scheme where the promoters misappropriated the assets. And very recently, just 2 days ago, the SEC announced its most significant DeFi case yet. And this one was a $100 million with BlockFi Lending LLC. This one I'll talk about in a little more detail because it's interesting. BlockFi paid interest on crypto assets deposited with the company. According to the SEC, at the end of 2020, the company held approximately $1.5 billion in crypto assets. The SEC alleged that BlockFi inaccurately described its collateral practices. It claimed that its deposits were over-collateralized, and the SEC says that wasn't true. In terms of jurisdiction, the SEC's primary legal theory was that BlockFi's interest-bearing accounts were investment contracts under Howey, the usual standard. In a first, however, the SEC also alleged that the accounts were notes, which are also defined as securities under the securities statutes and Supreme Court decisions, most notably the Reeves case that define notes. The SEC expanded its legal theories in that case in another way too. It included the usual Section 5 failure to register an alleged securities offering, but also alleged that BlockFi violated the Investment Company Act. And according to that theory, BlockFi was required to, but did not register as an investment company when more than 40% of its assets were in investment securities, so those securities would be the digital assets or loans of digital assets. BlockFi paid $50 million to settle with the SEC and another $50 million to a bunch of state securities regulators whose settlement was announced at the same time as the SEC. Now, what's worth paying attention to on this BlockFi settlement is it was, even though it paid $100 million, it was in a way a kind of a win for BlockFi because it achieved something that a lot of companies have been trying for but have not been able to get, which is not entirely, but almost the SEC's blessing on how it can revamp its business to survive SEC scrutiny and be deemed legal and let it carry on. And the SEC wanted to trumpet that piece of the settlement as well, even though it's not really part of the settlement. And the SEC went out of its way to highlight BlockFi's plan to register, so that's the key to avoiding the registration violations, a new crypto lending platform that it had developed, which is described and even diagrammed in the SEC's order. The SEC would need to formally approve a registration statement for the new product before it could go live, of course. But presumably, the agency wouldn't have highlighted the new product in the settlement if it didn't think it was likely to pass muster when it's reviewed. So, there could be a positive outcome for BlockFi from this rather expensive settlement. The vast majority of the SEC's crypto-related enforcement actions have settled, as in BlockFi. And that has supercharged the enforcement division's approach in this area. They've been winning, settling left and right, almost every case that they want to bring. At the same time, despite all that SEC, success, you might call it, the SEC would certainly call it, the cryptocurrency markets have continued to expand exponentially. According to the Wall Street Journal, these markets roughly tripled in value in 2021 to over $2 trillion. The result is essentially a war between a regulator and an industry, where the regulator has won almost all the battles, but has the resources to go after only a limited number of participants in a market that is enormous and growing. So both sides in this war are feverishly lobbying Congress for a legislative solution. Last week, the chair of the CFTC argued in a hearing before the Senate Agriculture Committee that the CFTC should be given a broader role in regulating the crypto market. Given the state of Congress these days, it's hard to predict, when, if ever, a new regulatory framework for crypto will emerge from the legislature. Eventually, I do think that new legislation is going to be required, but in the meantime, I think the next phase of this war will be in the courts, as more players in the crypto space have the resources and the will to challenge the SEC in court rather than settle. So let's take a little look at that. Now, so far, in cases that are actually litigated as opposed to settled, and where courts have ruled on the SEC's argument under Howey that various digital assets are securities, the SEC has compiled a record of 2 wins and 0 losses. So far, the SEC is winning in court as well as racking up the settlements. So the 2 wins were, one was in March of 2020, Judge Kevin Castell in the Southern District granted the SEC's motion for a preliminary injunction, halting the launch of a crypto platform by a company called Telegram Group. This was a very high-profile action. Telegram had tried what was then a novel structure. First, it privately offered or placed digital tokens to accredited investors under the Reg D exemption from registration. And then it planned to, for those initial purchasers, to resell the tokens more broadly. And Telegram argued that those resales would be decentralized because the company wouldn't be involved in them. And so under Howey, those shouldn't be deemed securities. That argument did not prevail, and Judge Castell, he did leave open the possibility that a cryptocurrency could become sufficiently decentralized so that it doesn't meet the Howey test. But he held in that case that the initial private placement and the subsequent sales of the grams, those were the digital coins, would be an integrated offering of securities under Howey, and that would have required registration. And Telegram later settled the case. The SEC's second win on the issue came in the Kick Interactive case in October 2020, also in the Southern District. The Kick had a digital coin called Kin and used a similar structure that Telegram had tried. Judge Alvin Hellerstein in that case granted summary judgment to the SEC on its claim that the token sales were a securities offering under Howey. And Judge Hellerstein also rejected Kick's argument that, based on due process, that the SEC's action violated due process because of the agency's supposedly inconsistent guidance and selective enforcement. Judge Hellerstein held that Howey and the subsequent case law provided sufficiently clear notice to market participants on what is or is not a securities offering. So to date, the only litigation result, contrary to the SEC's position, came this past November in a jury verdict. And it came in a private class action called Audette versus Fraser. Neither the SEC nor the DOJ was a party to it. But it still was kind of interesting because a federal district judge in that case in Connecticut was presented with the Howey issue, and he declined to rule on it and instead sent it to the jury, which deliberated on the case. And the jury came back and answered some special interrogatories and specifically found that 4 digital assets involved in that case were not securities under Howey. Now that a jury verdict, it doesn't establish a precedent that you can cite to another court, but it might embolden other crypto defendants to take their chances with juries rather than settle with the SEC. The most high-profile litigated SEC crypto case at the moment is the Ripple Labs case. Ripple Labs created a cryptocurrency called XRP, and what was quite different about XRP compared to many of the other digital assets that the SEC has challenged is that XRP was launched in 2013. It was in circulation, very wide use, for 7+ years before the SEC brought a case alleging that it was a security. And the case is highly controversial. A lot of the crypto pundits who watch the markets, market participants, SEC gurus, had assumed that XRP was similar enough to Bitcoin and Ether that the SEC wouldn't challenge it, wouldn't deem it as a security. And in fact, the case is now being intensively litigated in the Southern District. It was filed just before prior chair Clayton left office at the SEC, and now it's in litigation. Motions to dismiss have been pending for over 8 months. The Howey question isn't perfectly presented in the motions to dismiss, but still, the court's ruling could provide some important new judicial insight, which could either further embolden the SEC or perhaps slow it down in its war on crypto. In the meantime, I think the SEC is going to keep piling on the crypto cases. And this is a big frustration to the crypto markets and also to established banks and other companies that would like to get involved in crypto. They see a lot of opportunities, a lot of business potential, a lot of innovative applications, but there's a lot of those companies are standing back because they have a low tolerance for legal risk, whereas some other newer companies are willing to push the envelope more. So clarity would be a big help to the market, and we haven't seen it yet. It is time for the CLE code. GROW. If you want CLE credit, New York, New Jersey, Pennsylvania, and Kansas, type it into the Q&A and hit the send button so it registers. GROW is the magic number. And I'm running short on time, so I'm going to only very briefly touch on the remaining topics. Meme stocks and trading apps. A lot of folks probably remember what happened in January of last year. That's when meme stocks first became a thing. GameStop was just one of them, but here's a chart that shows the volatility went insane. It increased more than 1,600% between January 11th and January 27th. There was a lot of chatter, commentary, online forums, Reddit, and elsewhere, where a lot of folks said that they were ganging up on what they thought were short sellers and trying to do what was called a short squeeze. Brokerage firms were criticized that halted trading because of the extreme volatility. A lot of controversy. I'm going to skip past the details and just say that so far the SEC it was really just last week they issued a report that didn't really cast a whole lot of ideas for what, if anything, the agency would do about the meme stock phenomenon. Although last week the SEC proposed to shorten the settlement date from T+2, 2 days, to T+1, 1 day for stock trades. It's hard to see how that really addresses the volatility issues, but it really may be that there's not much that the SEC can or should do if investors want to speculate in stocks, which is really what the meme stocks were about. So I'm going to very quickly now mention accounting and financial reporting cases. As you can see from this chart, they tend to be down every time a new SEC chair is sworn in, but I would expect them to bump up significantly, particularly with the focus on ESG. I think we're going to see a lot more. And then also if the market declines, which there are signs that we may be in store for a pretty broad market decline, that can expose a lot of accounting issues, disclosure issues that the SEC goes after. So an important area to watch. Whistleblowers, the last part, always hot topic. They have transformed the agency and the way it brings cases. You can see the size of the whistleblower awards. This past year, there was a $110 million award. The year before, there was a $114 million award. Enormous awards in cases that have greatly incentivized whistleblowers. That's going to continue. When whistleblowers think the SEC is more aggressive, they're even more likely to approach the SEC. You can see the number of tips dramatically increased last year. I think that will go up again. And the subject matter of the complaints last year, there was a huge spike in manipulation. My guess is that had to do with the meme stocks. But I think the public company cases is going to be where we really see the huge, spike in whistleblowing in the current year and for the rest of the administration. Has Chair Gensler's enforcement program lived up to expectations? I would give them a qualified yes. They've announced some big changes. They've started to bring cases. I think we're going to see a lot more cases that are more aggressive, both in their legal theories and in their sanctions. There are some obstacles that the SEC is going to have to overcome or not. In the crypto world, I do think that the courts may start to erect some barriers. And if companies start to litigate more again, the courts may have something to say as well. Feel free to follow up with me if you have any questions or like to chat about any of these issues. Let me just give a final word about the CLE process. In about 15 business days, you'll receive an email with a link to your CLE certificate. Your webinar login details will be used to process the certificates. No additional steps are required. And the code word is only, the requirement only applies for those of you who want credit in New York, New Jersey, Pennsylvania, or Kansas. Have a great day, everybody. Take care. Bye-bye.